Good morning. My name is Lynn Gillette. I'm the president of the Silicon Valley chapter of AAII, and I know there will be people joining us for the next 5-10 minutes quite quickly. So I just want to welcome you and make everybody aware that our January program will be Claudia Hill talking about taxes 2023. She always does a great
Reset.
job.
Excuse me, not January.
Oh, I'm sorry. November. Second Saturday in November will be our program on taxes. And then we will not have another meeting until our 2024 January meeting. So we have a great program today. James A. Ward will be talking about estate planning, a very vital part of everybody's planning and putting together a life plan of how they want things to happen and keeping control of it. So I'm going to turn the time over to Bill Jump, one of our board members, and he will introduce the speaker. And you'll enjoy this program today. Thank you.
Thank you, Lynn. Yeah, this is a vital topic for everyone. Things happen, and sometimes they're very unexpected. So Jim Ward's my personal attorney for estate planning. He does a great job. He's a very experienced man. He has now 3 offices. He has his primary legal offices in San Jose and Gilroy, and he's opened a new office in Morgan Hill very recently. In addition to his legal talent, he is now a certified financial planner. So he's a well-rounded resource. Please welcome Jim Ward. Thanks, Jim.
All right, thank you very much. I appreciate the introduction and the invitation, and hopefully everyone will benefit and learn something along the way. So we have a slide deck that I will share, and then I'll go through those. So the way we've kind of agreed to do this is you can ask questions as we go, and we'll try and take some of them. That way you don't have to wait until the break. We'll have a Q&A there. And so we'll just go through it and see how many questions we get and make sure that everyone is understanding okay, so that we can address these things as we go. And I'll try and there we go, at the beginning. All right, so we're talking about estate planning, how we're going to protect what you have, protecting your interests, and so forth. And we're also talking about elder law planning. So the first portion is the estate planning, and then we do the elder law planning, which is primarily Medi-Cal planning, which is changing a great deal as we speak. Okay, so that picture of me is much younger than I am today, but don't let that worry you. I used to be younger, just like most of you used to be younger too. All right. So we're going to talk about why you need an estate plan, and what are the elements of the estate plan. Then we'll have a break. Then we'll come back. We can do Q&A during the break or as we go, whatever. And we'll talk about Medi-Cal planning and what's the difference between the elder law and the estate plan. So first of all, are you prepared? Okay, do you have an estate plan? Is it an elder law estate plan? That means is it elder law friendly? Okay. Will your legal documents work for you when they're needed? People say, well, I'm fine now. I say, okay, what's the date, of your next stroke or your first stroke or your heart attack? Well, those are unplanned events, and that's why you have to have something ahead of time. We all know, we've heard about other people that have had disasters where they got hit by a drunk driver. One of my clients, his wife got hit and killed by a boat while she was swimming. You never know what may happen. So you just have to have it ready. Who prepared your estate plan? Is it done right? Is it done by someone knowledgeable? A lot of the older ones were done by people who weren't attorneys. There was a wave of these things done in the 80s and 90s by people trying to sell you other things, so they would give you a discount on the estate plan to get it done. And a lot of those weren't done right. And then even if it was done right, you have to ask yourself, when was it last reviewed? Is it up to date? Do you have what you want in there? A lot of people come into me and they say, well, we did it when the kids were young and now the kids are in their 40s, so we don't need to have our brother or sister in charge. The kids can handle it themselves. Those types of things. So if you don't have an estate plan, get one. If you have one, you have to ask, will it work as you age? And if it hasn't been, reviewed recently, then get it reviewed by someone who's qualified. I cite here to Fisher Investments, not because I love them, but they do a lot of advertising. So they've got over 3,500 employees, over 123 billion in assets. They're a big company. I had no idea that they were that big, but they have a publication about 99 retirement tips. 7 of the top 10 retirement tips that they have are regarding estate planning or overlap with estate planning. That's how critical that is to your retirement. What's the difference between estate planning and elder law? Well, estate planning sometimes is known as death planning. That's basically focusing on the assets, getting them where you want them to go, avoiding the taxes, avoiding the probate, avoiding the litigation. Whereas elder law is sometimes referred to as life planning. It's more about you and your spouse, maintaining your quality of life and protecting your assets for yourselves and your heirs. So people say, well, I know where it's going to go when I die. Well, great. But how are we going to control it? Who's going to control it? If you have a stroke or dementia or you're ill, who do you want in charge? And do you trust that person? Do you trust them so that they will not steal from your other beneficiaries and they will not steal from you, and they will protect your quality of life according to your wishes? So I put together this estate planning continuum of age and wealth. You have to say, well, even 18-year-olds, they're considered legal adults, so they should have advanced directives. So sometimes we do those. We work with people. Their kid is going off to college. You should have these put in place. You get a little bit older, maybe you have a spouse and some children. Then a little bit older yet, maybe you have some assets. By the time you get to 65, 75, you've usually got a spouse, grandchildren, assets. You're figuring out retirement. You're thinking about assisted living facilities, nursing homes. Everyone has different priorities and things that come up in their life. So you have to consider all those. So how do you control where your estate goes? You can do, these are banking terms, or for investment accounts, POD, TOD, that's pay on death or transfer on death. So we had a lady recently that came in and, she was all concerned because her husband had died and he had a will that gave a bunch of stuff to his kids from a prior marriage. Well, it ended up that nothing went via the will because the bank accounts were all like this to go to her, and the real estate was joint tenancy. So they had 2 properties. So everything went to her, and nothing passed via the will, nothing went through probate. What about community property? That's another way to transfer. 2 types of community property. There's community property, and then there's community property with right of survival. So the regular community property is not the newer type with right of survivorship. That can cause a problem at death. If you want to hold your property as community property so it goes to your spouse, make sure it's held as community property with right of survivorship so it transfers immediately without having to go through the court and get any clearance from the court, any interpretation. Then you can also have a will. So if you have a will, that's considered a ticket to probate. If you have a will, you have to go through probate. And then we do the living trust. So the reason we do the living trust is to clarify all these issues, where everything goes, and to make sure that we don't have to go through probate. So with the living trust, you get to determine where your assets are going to go, when and how they'll get distributed, because sometimes we put conditions on there, to whom they'll eventually go, and is there language for a special needs trust? So a special needs trust is what a lot of people know about that. It's also referred to as a supplemental needs trust. So I had a couple come in last week with their 2 sons. We did their trust 5 years ago. They just wanted to review it, make sure it's okay. So one son is on disability. If he inherits, he'll lose his disability. And so he doesn't want his brother running his trust, and the brother doesn't want to run it either. So we have set up for a bank to run it, but they just want to make sure. And so that's the case of, we know this kid well, he's an adult now, he's in his 50s, that he's a special needs person. But what about someone who is fine now, but has a stroke or some illness or a car accident, and they end up being on disability at the time you die? So this should always just be in there just for the what if cases. And then in addition to this, you avoid the probate and the conservatorships. So what's the cost of not planning? Well, what's the cost of a conservatorship? A conservatorship can easily run several $100,000. You have loss of control of the assets. I've seen attorneys that get involved in these that'll bill $300,000 or $400,000 in 1 year. And that's all money going out of your estate. What's the cost? Let me say one other thing. There was a famous case in the San Jose area where the disabled youth sued the conservator for misuse of the money. And then the conservator, by law, used the individual's money to hire an attorney to defend themselves. So that just bled more and more money out of the disabled individual's trust. So what's the cost of the probate? Well, here's your probate fees. These are established by law, by the legislature. So you can say, well, why are they so high? Well, the legislature is full of attorneys, and that's why they're so high. So this is what you're going to have to pay. So half of this goes to the attorney and half of this goes to the personal representative. The personal representative is what you may call an executor, but the proper name in California is personal representative. Lao Tzu said, if you do not change direction, you may end up where you're heading. So the idea is, if you're not going the right direction, make a change. So with the proper trust, you don't have the conservatorship, we eliminate that. Let's say you are conserved and your spouse is going to be the conservator. Your spouse needs an attorney and you need an attorney to defend yourself against your own spouse, even if you've been married 60 years, to make sure that they're not stealing your money. So you got two attorneys involved in a conservatorship. We avoid the probate, we avoid the estate tax on the death of the first spouse, which is very easy to do these days because we have a very high exemption amount. And then the plan distribution was already established and in place. Warren Buffett, I'm sure you've heard of him. You're an investment group here. He said you have to stick within what I call your circle of competence. You have to know what you understand and what you don't understand. It's not terribly important how big the circle is, but it's terribly important that you know where the perimeter is. This is all that I do, okay? Now I've branched out, just as Bill said, with a new company for financial planning and investments, because my clients in the estate planning wanted me to handle their investments. I didn't want to, and I thought, well, what do I have to do? How can I get organized? How can I get licensed so I can take care of some of these people? Cicero said, let a man practice the profession he knows best. So people come to me with divorce issues or real estate property issue, the boundary issues, the fence issues, they want to sue the neighbor. I don't do anything like that. Okay? I don't do any litigation. I don't go to court. So I'm very focused on planning so that we stay out of court. So what about the living trust? That's a standby device. It avoids the probate, avoids the conservatorship, provides for ease of transfer, ease of titling, and it increases the speed of distribution. A will that has to go through probate can take easily 1.5 to 2 years right now. So besides the cost, you have a couple of years involved before the assets get out to your beneficiaries. Whereas with the trust, they can go out much faster if there's no litigation. So do you already have a trust? Is it valid? Once in a while, we get a trust that simply isn't valid. Are the documents signed? Sometimes people come in and they have a copy of everything, but nothing's signed. I said, well, can you get a copy of the signed ones? Oh, no, Jim, that attorney died or he moved away, he closed up. We can't get them. Well, you have nothing. Are they outdated? Sometimes they follow the wrong law. It's very rare, but when I first started, I saw some healthcare documents that came in that expired after 7 years or 5 years. So it's like people say, well, no, I have a healthcare document. I look at it, I said, this thing expired. I don't know why they would do that, but they were done that way. Was it funded? This means, are your assets actually placed in the trust? Are they owned by the trust, or they haven't gotten there yet? And is it the right fit for you under the current tax law? So is it valid? Do you have the originals? Okay, how old is it? Was it done during the cave era? And everything's falling apart. We get these trusts that the staples that they use, they're now all rusted and the papers are falling apart. But sometimes they're still valid, sometimes not. The act of funding a trust is when you place the assets into the ownership of the trust. So it's just like having a safe. So if you buy this safe and you bolt it down to your garage floor, and it's an incredible safe and it's fireproof and all that, it only protects the assets that you place into it, and close the door and spin the knob. Okay, so if you haven't done that, your assets aren't in the trust. A lot of times with real estate, we find that it was taken out of the trust for one reason or another, perhaps for refinancing, and never put back in. So you want your assets in the trust. So is the trust the right fit for you under the current tax laws? What happens? Now, we've had a couple of big cases of the old AB trusts that caused problems, and the family wasn't aware of it. So in one case in Los Altos, the lady had been bedbound for 2 years and was now out of money. So they called me and they said, Jim, what can you do to help? Well, it turns out her husband had died years ago and they had an AB trust. So I said, well, if we don't get rid of this trust, the daughter who was going to inherit would pay a massive capital gains tax on the father's or the husband's half that had died a long time ago. So simply by changing that around with a court order, we saved the daughter about $350,000 in capital gains tax when she inherited from the mother. So you just have to understand how things are going to work long term. Another example I'm dealing with right now is the son and his brother were gifted or sold, that they paid a small amount of money for a ranch that was owned by the father. And then the one brother bought out the other brother. So now, he came to me and said, well, I need to do a trust. And I started talking about it. Well, the dad is alive at 101. I said, if you can get this back to your father, and we check the tax law, once it goes to the father has to live 1 year. Then we'll get a step up in basis. So that son will save $400,000 to $500,000 in capital gains tax, because after his father passes, he's going to sell it and he's going to move out of state. So the idea is, how can we, get it into the father's name without creating a tax problem? If the father can live 1 year prior to death, then the son will save $400,000 or $500,000. So you just have to know how the laws apply to your situation. Who's qualified to advise you? So because this is what I do, I see this all the time where so many people come in and they have a huge capital gains tax problem. And the realtor said, oh, it doesn't matter. You can just sell the house. Well, the realtor gets their commission and then the client pays a fortune in capital gains. So I had a couple, the husband was going downhill. The realtor convinced the wife to sell 2 rentals in Sunnyvale. And he said, it's a good market, you have to sell now. Well, the realtor got a commission of like $100,000, but the lady then owed $1.5 million in capital gains tax. She did not need the money. She was convinced to sell these things because it was a great market. Yes, it was a great market, and perhaps it's gone down a bit, but not much since then. $1.5 million down the drain in tax. If she had needed money, we could have borrowed it. If she already had income from other rental properties, total waste of money. What about the financial advisor? I am a financial advisor, but I still pick on a lot of these people because they don't understand what's going on globally for the client. So with Prop 13 and Prop 19, which I'm sure that most of you are somewhat aware of, we had a couple and they had one daughter who lived in a small house that they rented to her, and that was to pass to her at their death. She's never earned a lot of money. She doesn't have much in the way of education. Her sister, however, is married and wealthy. And so, how do we figure everything out? So the financial advisor said, well, none of that matters for the Prop 13. You're just worrying about nothing. So the deadline passed for Prop 19. Then they came to me. Well, now the younger daughter who doesn't make money is going to have to sell that house when the parents die because she cannot afford the higher property tax that she'll have to pay. And the financial advisor, the other daughter who is wealthy, said, yeah, the financial advisor threw us under the bus on this one and totally screwed my sister. Well, screwed the whole family. What the family wants is to protect her. And now it didn't work. So you have to think about who you're dealing with. I tell a lot of stories as I go along, and someone asked one time why, and other people said, you know, they learn a lot from the stories. So I tell the stories by way of example, and hopefully you'll understand. So one other story, this guy who was a medical professional, had a couple offices, was making a lot of money. He had a heart attack and dropped dead in the office. Well, his widow came to me later. She was referred to me, and so we talked about what she had in the 401k, IRA kind of stuff, and what we're doing. And so she told me, well, they're sending me all the money on Friday, and this was like a Monday or Tuesday. And so I'm what they call a elite advisor member of Ed Slott. So if you follow any of the IRA stuff, he's probably the #1 advisor, IRA advisor in the nation. So I knew enough from those meetings. And so I said to the lady, I said, no, you can't take the money. We're going to have a massive problem here with taxes. And she says, well, what do you mean? They're going to send it to me. I said, if they send it to you, don't cash the check. And so I said, let me do some research. So I called another buddy, and he was out of town. And so I just poured into it myself. So Thursday night late, you know, it was close to midnight. And I don't know about you guys, but I like to go to bed by 9:30 or 10. I'm still trying to figure this thing out. So I composed a long email, sent it to her. I said, send this to the 401k people. I said, I think there's been a violation of law and a couple different steps here. So everything that you're supposed to do to put it into the trust is invalid. And so within a half hour in the morning, they read it by their legal, and they said, oh, Mr. Ward is correct. We're just going to roll it over to you then. So I saved the lady like $350,000. This is a lady who hasn't worked since she had her first child. So, you know, we saved her a lot of money just by knowing, you know, this isn't the way to do it. So what do you have to have for your documents? So I have these levels here, right? So level 1 is what you must have to protect yourself. That's the Advanced Health Care Directive, sometimes called Healthcare Power of Attorney, but people get confused with power of attorney. So I don't like that term. When I think of power of attorney, I think of finance. The authorization for the release of HIPAA, you know, your protected health information, that's the HIPAA waiver. There's a federal one and there's a California one. The directive to physicians is an end-of-life statement that says whether or not you want to be kept alive artificially if you're terminally ill, and then you enter a vegetative state. And then the durable power of attorney. It's a financial power of attorney. Who can sign your name, move your money, pay your bills? If you want to have the proper asset distribution, you can do that with a last will and testament, sometimes called a will. A holographic will is legal in California. That's a will written by hand. Okay, you can't type it out and sign it. A couple pieces of it could be typed, but the main part has to be written. If you want to do that, and I've had people transfer a house or their other assets via a handwritten will because they couldn't afford to pay me, you can do that. That's legal. But if you want to, but that'll have to go through probate. So if you want to avoid the conservatorship, avoid probate, save time and money, then you're going to have a revocable living trust, which is also called the living trust or the family trust. If you have a trust, you also have a will. But rather than giving anything away, it's what's called a pour over will. It says, now that I'm dead, everything I have that's not in the trust, pour it into the trust. Okay, so then everything ends up in the trust. That's what you want. Okay? And then when we do the Medi-Cal, we frequently use a Medi-Cal Asset Protection Trust, which is irrevocable, but it also protects against scam artists, and it protects against you getting scammed when there's dementia, and it protects against family members trying to give you a document and have you sign it at the last minute, which happens a lot. So this is my background, okay? The JD you're familiar with, that's my law degree. LLM is a master's of law. That's a postgraduate specialization degree. But I started out in international agriculture. If you come to the office, you'll see a map of all the magnets where I've been all over the world. I used to live in 4 different countries. I was in banking, real estate, financing, consulting. Then I was made a partner, then what they call a partner in charge at KPMG. If you've been around long enough, you may remember the firm as Pete Marwick. So there were there were the big 8, the big 7, the big 6. Now they're down to 4 with Price Waterhouse, Deloitte Touche, and I can't remember the other one right now. Then I went to work for Merrill Lynch at the private bank in Boston. I had my stockbroker licenses. Then I went to law school. Then I went to the postgraduate law degree. Then later I got the CFP, and then I got the RICP, which is the Retirement Income Certified Professional. So those are my credentials. The question is, are you getting what you're paying for when you do these things? I've had people come in, you know, it's clear that they saved a lot of money when they went to a paralegal or legal Zoom, but then I said, it's not going to work. And when they come in, they've already had a stroke and or they have dementia and their kids come in, we can't change anything. It's a nightmare. This is one of my favorite slides. I had this made into a poster in my office. So POM, if you know anything about it, is pomegranate blueberry juice. It says around the label there, if you can read it, 100% juice. Minute Maid is owned by Coca-Cola. They have their own version there of pomegranate blueberry juice. So POM sued Coca-Cola, and they said, you're doing false advertising, you're destroying our market. So, of course, Coca-Cola fought it, and it went through the courts, and they lost, and it went through the appellate courts, they lost, went all the way to the United States Supreme Court, which is highly unusual that any case gets there. And it was a unanimous decision in favor of POM. You know, Minute Maid was just scamming consumers and had the same color. Okay, but it was primarily apple juice in there. It was less than 1% pomegranate juice. And so, you know, the court asked the attorney for Coca-Cola, you know, what are you doing here? And they said, well, you know, we've labeled everything properly. So anyway, it was not proper. Everything was, you know, so the Supreme Court said, yes, Minute Maid, Coca-Cola, you destroyed POM's market. Now go back and calculate the damages. So when I tell this story, people say, oh, I used to buy that Minute Maid. It tastes delicious. Maybe it did taste delicious. It was sugar water, but it didn't have the antioxidants that people thought they were paying for when they were getting the pomegranate blueberry juice. So it's the same thing with a trust. Are you getting what you paid for? Abraham Lincoln said, how many legs does a dog have if you call his tail a leg? 4. Saying a tail is a leg doesn't make it a leg. Just because someone says this is a trust doesn't mean it really works like a trust. This is all I do.
Hey, Jim.
Yeah.
Excuse me. There was a question came in the
Okay.
chat window. Person is asking if they can do something other than a 50-50 in the bequeath to their children.
You can do anything you want. Okay. You can disinherit, or we can do it differently. We get really creative sometimes, but like one guy came to me and he had 3 kids. It was 33%, 33%, 33%, and 1% to a charity. So when we're redoing everything, he says, you know, I said, you still want the same charity? He says, well, do I have to have a charity? I go, no. He said, well, the other guy said I had to. So really, the other attorney didn't know math. So instead of 33%, we just said 1/3. Okay? So there we didn't give anything to the charity. Sometimes it's 60-40, sometimes it's 90-10. Sometimes, you know, people say, well, I want, you know, 10% to go to the grandkids. And then the 3 kids get 30% each. So you can do anything you want on those. What we did with the disabled kid that I spoke about recently, we did it several years ago, but we reviewed it again. If they wanted 50-50, so if the disabled son received half of the IRA account, he would have lost his disability. So then we had a formula that says whatever half would have been, we reduce, it'll all go to the healthy brother. We reduce that half by 25% for taxes, and then give the disabled son that much more of the main pot that is not going to cause a problem for the disability because it goes into a special needs trust. So I explained to him, again, it's not an exact calculation, but we know that the healthy son that inherits is going to have to pay taxes on the IRA when it comes out. So, but we have people that cut out one or say, no, I love Johnny, but I already gave him 200 grand. So, you know, everyone else gets 200 grand first, and then we split evenly. So you can change anything you want, right? Hopefully that
Okay, we
answers.
have another question.
Right.
If I register a brokerage account as TOD instead of a trust, is that okay? Any potential issues?
The problem is TOD doesn't happen until you're dead. So the question is, how do we control that money if you stroke out? That's why I like it to be in the trust, because maybe we need to use it for you. So depending on the terms of the power of attorney, we may or may not be able to use it the way we see fit. Whereas if you have a good trust and it's owned by the trust, then we have that set up. So sometimes people will say, well, I want everything in the trust for my 3 kids, but I do want to give this other account to my stepdaughter. You know, my husband died, but he wanted something for her. So I'm going to keep that one aside. I have enough in the trust to live off of. And that $65,000 account will transfer to my daughter or to my stepdaughter at death, assuming I don't need it. So we don't give it away ahead of time. So it's there if you need it, but it's not part of the trust. It's a separate one.
Okay, this is a good time. I'll bring one up just for the benefit of the audience. Suppose I get a power of attorney from another person, and I die. That means, or the person that gave it to me dies. That means that the power of attorney is dead. Is that correct?
That's correct. The power of attorney is under the law of agency. You can only have an agent if you're alive. So I've had people, one was a CPA, she said, well, my mom died, but I'm still going to use this. Well, that's a violation of law. When the principal, who's the person that signed it, when the principal dies, the document dies.
Thank you.
You cannot have an agent after you're dead. At least according to law. Maybe you have a winged angel on your shoulder somewhere, but not according to law.
Okay, so we can proceed.
All right, so who's this guy? You remember him? Orville Redenbacher. What's he do? He does popcorn. He said, do one thing and do it better than anyone. Okay, so sometimes we have personal injury attorneys that try and do a trust for their client after they receive $500,000 or $1 million. And most of the time, those things are done wrong, right? So you have to, I have attorneys who have come to me and they've done their own trust before, but they were a litigator or they were a real estate attorney. And they say, Jim, we know it's not right, but I did it years ago. And then we have to redo it and clean it up. So you have to make sure it's done by someone that knows what they're doing. Albert Einstein, he said, it's not that I'm so smart, it's just that I stay with problems longer. So I stay with a smaller set of problems. Right? I'm not worrying about some of those other issues, such as how we handle conservatorship law. You know, what do we do if the neighbor encroaches on your property or their water is diverted to your property? I just work with this. Probate litigation is the fastest growing area of the law. Why? We have poorly drafted wills and trusts, and we also have the largest transfer of wealth in U.S. history. I heard a probate litigator speak a couple of years ago, and he said he loves LegalZoom. It creates so much business and so much litigation that's why his business is booming. You have to understand the law, the precise understanding of the law, what it means. So I use this example. So you come up to this stop sign and it says stop. So I understand there is such a thing as a California stop, but that's not legal. So what the stop sign says is you have to stop. You actually have to stop. Now, what about a red light? You come up to a red light. You know, what do you have to do? Well, people usually say you have to stop. Well, that's not true. That's not what the law says. You never have to stop at a red light. What the law says on the red light is you simply cannot cross the white line until it turns green. So if you look at a lot of people, they time it, or the truckers, they time it to save on the brakes and the gas, and they coast right up to it and it turns green. So very different law. Stop sign, you must stop. Red light, you simply cannot go beyond a certain point until it turns green. So you have to understand how we're going to treat the law. What about the power of attorney? The power of attorney is one of the most powerful documents you have. It has to be done right. Does it contain the powers that your agent might need? So people, I had a lady, I had to do a mediation, 2 sisters and 2 brothers, and they were fighting, and one brother was supposed to stay in the house for life. He wasn't able, he didn't have the abilities as the other, but the other brother, who had a lot of money, was demanding, mom's house be sold so that he could get his share. And the sister said, no, there's a big problem. So one of the sisters said, well, will you look at my stuff? I said, sure. So she said, well, here's the power of attorney. I said, well, that won't work. And she says, you didn't even look at it. I said, that's the statutory form. It's 2 pages. It has A through N. If you initial N, it gives all of the above. But for certain issues, you don't have the authority in that power of attorney. We will not be able to do things. That's a typical 2-pager. Mine is like 27 or 29 pages. Do you need to have someone with the authority to operate your farm? Probably not if you don't have a farm. Operate your business? Probably not if you're retired. But we put these things in just because you never know. So is this your power of attorney? You have 3 distinct tools there, okay? Or did you do a little bit better job and you got this one that has whatever that, 10 or 12 tools, or you came to see me and you got this one, right? So the issue is, what's going to come up? So decades ago, when I was in elementary school, we had this exercise of you're packing a covered wagon, you're crossing the United States. What do you put in there? What do you need? What might break? Okay. So this is the same thing with the power of attorney. What might happen? So the question is it elder law friendly? Well, we've done a lot of specialized Medi-Cal trust to get people eligible for Medi-Cal to pay for the nursing home or give them home care. And most powers of attorney will not have the things in there that we need. They simply won't work. So if the elder is still competent and able to sign, we can have them do another one. But what if they're not? So I had a brother and sister come to me and they said, well, Dad had a massive stroke. We need you to protect everything. I said, well, he's got a bad power of attorney. I said, as soon as you spend that $400,000, then he'll qualify. But nobody has the legal authority to protect that $400,000 to get him on Medi-Cal, right? Those are the issues. So what's in the power of attorney? We have to be able to allow gifting. We have to create new trusts. Sometimes they say my agent should be able to do everything that I could do. So I said, really? That's not legal. Certain things have to be enumerated in the power of attorney by law, or you can't do those. You can't just say, my kid can do everything I could have done. That doesn't work. So why is this so critical for your family? Because we're not doing estate improvising, we're doing estate planning. Okay, we're not winging it here. We're not guessing. We're making an actual plan. So are you prepared? Do you have it? Is it elder law friendly? Is your documents going to work when you need it? Who prepared it? When was it prepared and when was it last reviewed? I recommend that people knock the dust off and look at it every 3 years. If you're my client, come on in. But the issue is, does it still have the people you trust? I have one couple that they've been in several times. And I always say, why are you back? Well, the husband's 91, the wife is 89, they have no kids. And everyone they named to be in charge keeps dying. So this last time they came in earlier this year, the number 1 guy found out he has stage 4 cancer. He said he's heading back to Texas to be around family and die there. And the other one, who was in his 40s, got hit by a drunk driver and killed. So they have to keep on changing it to add new people. So you have to make sure you have people in there. Hopefully, like the people, an example this week, they're in their late 50s, they're in their early 60s, I think. Well, they had named their parents. Well, but now your parents is like, are they still capable of taking care of you and making decisions for you when the parents are in their 80s? So you have to be prepared. Okay, if you don't have a plan, get one. If you're having a estate plan, will it work? Is it elder law friendly? Right? Has it been reviewed by a qualified elder law estate planner? Thomas, Jeff?
Jim,
Yeah.
excuse me, Jim, here's a juicy question.
All right.
What is the best way to structure our trust to only give to our children and protect the funds from their spouses?
That is pretty easy, okay, that's the standard. So we say, if you have, let's say, a son and a daughter, usually if the son dies before the second parent, his share will go to his children. And then that doesn't go to his spouse. If the son dies before the second parent and has no children, it'll go to the daughter. That's fairly standard, but sometimes I see them and it's not. I had a lady and, I reviewed it and I said, well, this says if your daughter dies, it all goes to the other daughter. And the daughter and mother looked at each other. That daughter will never give anything back to the other one's children. And the mother had had this already for 10 or 15 years that didn't know that's what it said. So inherited property or gifted property is separate property. Even if we're in California, it's a community property state. So if you die and leave something to your daughter, it's hers. So in the event of divorce or whatever, it's hers. But if she commingles it or adds her husband on there, then she can lose that protection. There are trusts that go on to protect that, okay? But I had someone come in recently, she had 1.4 million sitting in that trust. She wanted to get rid of the trust because she's in a long-term marriage, she trusts her husband, she has the kids that she trusts, all that, and the attorney refused to do it. Well, when I went through it, that attorney was named everywhere in there. Anytime you wanted to cough or sneeze, you had to go back to that attorney, and so they could charge you more. So we had to get rid of that trust so that she didn't have to keep on paying for that and so that she wasn't burdened by that. So it just depends on what you want to do and how concerned you are, right? But we can work that out. That's easy. So Thomas Jefferson said, it takes time to persuade men to do even what is for their own good. So you have to do this. I know it's good for you without being too parental. I know that it's good for you. But even if you know it's good for you, you have to get it done. And sometimes people just don't, and then all of a sudden it's too late. Benjamin Franklin, failing to plan is planning to fail. You got to get it done. Take care of yourselves and your families. So now we have a Q&A period. I don't know if there's more questions or not.
I'm going to check here. I think that's we've covered the questions so far. Oh, here we go. When would you use a fiduciary?
Okay. There are professional trustees, fiduciaries around. I've dealt with a few of them. I was referred to a couple before in a couple of cases, and both of them said, this is a perfect case for us, but we aren't taking any new clients, we're full. And so the good ones tend to be full. Then I had a client that came to me, he had about 10 or 12 million bucks, no kids, no wife. And so he said, Jim, I found this fiduciary, he's a good guy. I said, okay, if you like him, you want to use him. But I had to use him in another case. And once he signed up and was getting his income, he never returned calls for anyone. And he stiffed the accountant that had done for the work before. It was just a nightmare. And he never called back. So what do you do? So Fremont Bank, every bank has their own trust department, including like Schwab and Merrill Lynch, all those, because they make a lot of money off of these. Fremont Bank has a good reputation in working with disabled people. So a lot of times I name Fremont Bank. So the way we go through the progression is it'll be like you name your son. If something happens to your son, if you don't have anyone else, you name me, but not to do the job. People always want me to do it and be the trustee. I'm not going to do that. That's a different line of business. But you name me to name someone, right? And then if I check out, because I got hit by a truck, then we have Fremont Bank. So we have a succession of people in there. And so if I can find either a corporate trustee or a bank trustee or a fiduciary that I like, I can name them. And if not, then it defaults to Fremont Bank. So some people say, well, all my money is at Fidelity. They have a trust company. Well, if you want that, you name that. But you have to realize how these big trust companies work. So you may be disabled yourself here, or your child or grandchild disabled, and the person making all the decisions is in Florida or New Jersey or Arizona. So they'll hire a care manager, they'll hire someone to oversee the local situation, but there's a charge for that. So you have to understand how these things work. So, there are attorneys that say you should never have your family, and that may be true if you have 20 or 50 or 100 million bucks, but I'd like to use a family member if we have one that you trust.
Okay, we have two more questions that are up. First one is, are your trust documents full of legal language, or are they written for laypersons to be able to understand and manage?
We do both, okay, and they're mixed together. And so I had a guy that criticized me that he couldn't understand it, and they'd already paid to review it. And I said, well, come in, I'll answer all your questions. And we have people that come in, they got 20 stickies on there. We go through it all. Well, this guy refused to come in. I said, well, I'll answer it all. 3 years later, they filed a complaint asking for their money back. But I had all the documentation, all the emails, and I said, look, I've offered so many times to explain all this. And the California bar sided with me. They said, no, look, Jim, you did everything you're supposed to do. It's not, it's not unusual. Sometimes, though, I've taken to telling people, I don't have the time to send you to law school. So we'll explain things, but some things don't pertain to you, such as the example I gave you of running the farm, okay? And other things you don't think will pertain to you because you don't think any of your kids will be disabled, but it's just a what if. And so some things are in there that, we hope to never use. Sometimes people don't understand certain things, but I had a client that called me recently, and I don't know why, and he's in his 60s, so he's not very old, and well, by my standards. And he said, what happens if one of my beneficiaries is incarcerated? And so I thought, well, there's got to be something going on in his family. Why is he asking this question? I said, we have that, and we've had that case. So I said, buried in the back here, there's a lot of pages here, and no one reads some of this stuff. It says, what happens if the individual is missing or incarcerated? So we had a lady who died here locally. Her son was in prison in Arizona. And when you're in prison, they help you a lot. They open your mail for you. So the prison opened the mail, realized the guy was going to get like $90,000, but he owed like $50,000 in back child support. So they said, okay, well, we're taking the child support and we'll hold the rest for you. So he was furious, but I said, well, on the other hand, when he gets out of prison, he has no debt. So, we have clauses there even for that. So the documents are long. We try to keep it as simple as possible, but then we also provide, at no charge, we just explain it to you. We want you to know what it says. Now, I'll give you another example. A lady came in and I knew her, okay? And so she came in and she is a writer. She writes things all the time, and so she's good with English language. So she came in and she had 20 or 30 stickies. And because I've known her for years, I said, look, I'll explain all those things to you, but we're not changing anything. Okay, we went through it, went bit by bit, and she wanted to understand how it applied. Then we got to the point of the pets. So she said, I want the person in charge to know that my pets have provided me with tremendous amount of love and affection over the years. And, if they don't take care of my pets, they'll burn in hell. So I said, okay, do you want me to write that in there? And she said, yes. I said, do you want me to include the burn in hell clause? She said, no. Okay. You just have to let them know they have to take care of my pets. So we modified it and put that in, even though we already had who was supposed to adopt them and how much money they would get for each dog or each cat. Okay. We still added the love and affection from the pets section, right?
Okay, we have another one here. Does one need a trust if one is single and has no children?
Well, the question is, will you need someone to make financial decisions for you and take care of you prior to your death? All right, so the trust makes it very easy for us to sell your house, hold the money, pay for your care, that kind of thing. So I'm convinced with my experience that everyone listening here today is going to die, right? None of us are getting out of here alive. So the question is, what will happen between now and death? So how do, I had a lady came in last week. She's looks a lot different than she did 5 years ago. Well, she's been in and out of the hospital so many times, but because of the trust document, then her daughter is taking care of everything. And the daughter knows you get a reverse mortgage if you have to. You liquidate all my accounts, you keep me at home. If I die and there's only 25 cents left, that's okay, but you keep me at home, right? So, if you have a good trustee, they know what you want. So the problem is, who's going to run the show? So I had a guy come in and he says, Jim, he says, I have no friends, no wife, no children, no family. I don't like people. I said, well, okay, that's a little bit difficult. Okay. How are we going to take care of you because you've got a couple $1 million? And he says, I don't know. I said, you have to think about it. So he called me back like an hour later. He says, on the drive home, I realized I have 2 friends from high school that would never steal from me. And they would always help me and they'd do anything for me. So he says, I want those guys as trustee 1 and trustee 2, right? So you just have to think about what may happen and who you trust to make decisions for you.
Okay, here's, I think, the last question that I see. I thought a pour over will was to cover items not in the trust. If I understood you correctly, if something is not in the trust after you pass, those items can be put in the trust. Is this correct?
A pour over will say the distribution is to the trust. Okay. So, if you have a trust, you have a pour over will going with it. I say it goes like together, hand in glove. They're part of taking care of you. So let's say you have a car and you die. Well, the car is not in the trust. So either we sell the car, put the $20,000 in the trust, or we transfer ownership to the trust, which is more awkward, or we give it away as part of the distribution of the trust. Let's say you bought a beach house and it's $1 million and it didn't go in the trust. The pour over will transfer it to the trust, but because it's more than $185,000, it'll have to go through a full probate with the court before the court transfers it to the trust. And then it'll be distributed via the trust or sold via the trust, whatever. So the pour over will picks up everything that's not in the trust and transfers it to the trust. It pours it into the trust, just like you're pouring wine, you're pouring water.
2 questions. If the will specifies different beneficiaries than the trust, can they contest it if it's not in the trust?
It depends. It depends on what's governed by the will. That gets sticky. So, for instance, we always want the successor trustee to be the same as the personal representative. So you don't have Bobby running the will and Susie running the trust and they hate each other. Okay. So sometimes people will give away certain items in the will, but they're better to give away those items in the trust. And then, so everything just goes to the trust and they get given away that way. So, what are the reasons for having it in the will? Sometimes they said, well, that's what it was before. I say, well, let's just do it via the trust. It makes things a lot easier.
When you title,
let me just go back. Let's say it's firearms or jewelry, which are common that people want to give to certain people. So the documents that I use allow for what's called a separate writing. So that, you sign something saying everything goes to the trust, but you do a separate writing on your own. You say, this pistol, this rifle, this necklace, whatever goes to these people. Now, if you only have one person that gets all the firearms, it's easy. You just say all firearms go to Bobby. The problem with the jewelry and the firearms have serial numbers on them. They have some sort of identification on them. It's a really old antique. They might not, but you can identify them. My example that I give with the jewelry is we don't want you to say, Susie gets the pearl necklace. We open the jewelry box and you have 4 pearl necklaces. Well, which is the one for Susie? So you got to think about that. We have women that take pictures of all the jewelry and write on it, who gets each piece. So you want to be very clear on those.
When an asset is titled to a trust, the administrator normally copies a number of pages of the trust. Do you need to present anything more than a death certificate at that point, or do you still need the original signed trust?
Well, the beneficiaries, okay, let's say I have 4 kids. I just inherit 2, and I have 2 as beneficiaries plus the Red Cross. Every beneficiary is entitled to a copy of the entire trust, and the natural heirs, even if they were disinherited, are also entitled to a copy of the entire trust. And when I say entire trust, we're talking entire trust.
And
So
that means if-
sometimes to open a bank account, they want the first 2 pages and the signature page. Well, that's, upon death, they get everything.
so they get a copy, not the original signed copy, correct?
That's correct. The only time we need the original is of the will to submit to the court, but most of the cases we don't have it, and so they just tell the court we don't have it, okay? But copies are fine. Now, you have to look at the copies and you have to ask yourself, is this an accurate copy? Or is there something else? I had a lady come to me and she said, I have a problem. Mom died, and here's the trust. And so I referred her to someone because she said, we're going to have problems with my brother and sister. And I sent her to another guy that does litigation. So when I'm looking at the trust, I realized the one page that gave her the whole house, which was a couple of $1 million, instead of to everyone else, was a different type of paper. So she had matched the font and the margins exactly in the paragraph structure, but she had altered that one page. And so if she had just run it through a photocopier, I never would have known. So, she left. I immediately called the other attorney. I said, don't take the case. It's fraud. Okay. She has altered the trust. Don't take it. And he said, oh my God, thanks. But so we see fraud all the time. And so it's a question of, do I catch it or does someone else catch it or the other beneficiaries catch it? I had a brother and sister come to me and they had a typed will. A typed will needs 2 witnesses in California. Sometimes they bring them in, they're notarized. Well, that's not a legal will in California. So you have to wonder how it got done. So it had 2 witnesses. Now, you should have the printed name and the address of the witness and the signature, so you can find that witness. Both of the signatures were just a squiggle. I'm right-handed, so it's like I made the squiggle with my left hand. And they said, no, Dad really got upset with our brother, so he cut him out. I said, I think the court's going to throw this will out. I think it's fraud. Right? So you have to ask yourself, will it stand muster? And who's going to contest it?
Okay, we have another question here. How much does Fremont Bank charge?
Almost all the banks have a sliding scale depending upon the level of assets. So they're charging a higher percentage for a small one and a lower percentage for a large one. So it depends on what they have to do. So I met with years ago when I was first in the business, I met with a trustee from U.S. Trust, which was bought by Bank of America. And so I said, you charge those same fees on like $1 million house or a $2 million commercial building? And, even with those all leased out? She goes, yeah. I said, but that's a lot of money to pay. And she said, well, we have to make sure it's insured. So essentially, they're just making sure it's insured so it doesn't burn down, but they're still charging as if they were managing liquid assets. And so you have to find out how they're going to charge and what are your assets, but they all seem to publish a good scale. So you can get a copy of that. You say, what are you going to charge? Here's what my estate is. Well, okay. So your estate is $3 million, but after we sell the house and distribute, we only got $1 million left. So it's going to be a higher percentage on that. So it's usually a declining percentage. So it's X percent on the first $1 million, then it goes down, that type of thing. My sister-in-law just retired she worked as a trust officer for a big bank in San Francisco. So, sometimes she had to travel a few hours away, go see properties and check on them, make sure everything's okay. Or or they had to, as a trustee, they had to manage the litigation between the tenant and, you know, the trust and so forth.
Okay, here's a question. How does medical planning work? Can you give a high level overview?
We'll do quite detailed after the break, but we keep on having questions. I'd like a break. So there says
Okay.
break. All right. So how about, I only need 4 minutes, but I don't know what you want to do for when we come back.
Let's do 8.
Let's come back at 10:10. Is that all right?
That's fine.
Okay. All right. I'll be back at 10:10.
Okay, break for 8 minutes.
The poll is up for those who please respond to the poll.
Thank you. Thank you.
Thank you for those that answered the poll. And I have I believe, 2 or 3 questions as they come in. Do you have blank questionnaire documents to fill in to create the final documents? HCD, HIPAA, waiver, living will, etc., etc.
No, I don't. I first started in the business, worked for a guy that had like a 17-page form. No one made it past the first page and a half. It's asking a lot of personal information that we don't need. You know, it's ridiculous. I do the interviews in person, and we talk through what are the documents and why do I need the answer to this, and who is the appropriate person to slot in. So I do that all face to face.
Okay, next question. We have a trust to be managed by a local fiduciary. In 5 years from now, we will be moving to a life plan community known as a CCRC, continuing care retirement community. How does this change my trust? Do I need to change the fiduciary to the CCRC?
I would not name the CCRC because there's some of them are facing massive lawsuits right now. I don't think you want them handling your money, making your decisions for you. So you need to go back to the fiduciary and say, once I move in, can you still handle it? So depending on the CCRC, someone has to decide whether or not we're going to sue them for not taking care of you. Other than that, we just have to issue them a check. So there's not a lot of decision making in there. And so you have to ask, how much money do you have? You know, how much is the person going to charge you to write a check? And what are your options? Okay, if it's not that fiduciary, who else do you have? So I had one couple and they were just really troubled, you know, with their son and daughter, you know, I couldn't do it. What are we going to do? And so I said, well, shake the family tree. What about a niece and nephew? And they were like stunned. They said, well, we thought it had to be our kids. No, it could be your brother, your sister. It could be your brother's neighbor. And so we have people that pick a coworker. We have one that second marriage, a lot of problems with the kids, actually not the kids, but the son's wives. And it's just been chaos. So the husband's a retired engineer. He appointed his friend who worked with him as a retired engineer. So this guy is in charge. And here's another retired engineer in charge after him, because we don't want either of our sons involved because of their wives. Another couple was very clear. They said, we trust our daughter because she got a divorce. We would trust our son too if he would divorce that greedy woman that wants us to die. You know? And so you have to figure out who you have. So if the fiduciary can handle it, or you know, maybe you say we have other options now. Where are those people? They say, well, they're in Indiana. Well, okay. Most of Indiana has internet and electricity, so they're okay. But what about the person making the healthcare decisions? So I had a lady in Gilroy, and she says, well, you know, I want to name my daughter here in charge, but my other daughter is adamant that she be in charge because she's a doctor. I said, well, okay, that makes sense. But she lives in Saudi Arabia. I said, are you kidding me? I said, she says she'll come home. I said, well, I used to live in Qatar, which is connected to Saudi Arabia. That's like a 24-hour trip or more. So I said, she's not coming home once a week to check on you. So I said, you have to be reasonable here. That's just not reasonable. So I said, name both daughters and encourage the local one to call her sister in Saudi Arabia for serious medical issues. Right? So you have to say what makes sense. Right?
Okay, the next question is actually administrative. We try to post the recording around a week. We have a board member who's traveling, so it might be a little longer than a week. Okay, the next question for you is, for a person just getting started, do you have an action plan, i.e. what to do first, second, third, etc.? I see levels 1 through 4. Should these be done in that order?
You need to do all of them other than the irrevocable Medi-Cal trust. All right, that's the prudent thing to do, especially if you own real estate or you have loved ones, spouse, children, whatever. If you have children under the age of 18, you need to appoint guardians too. So that's really what you need. Now, we have people that say, for instance, a kid going to college or someone who, rents and they're in their 80s and they have no money, type of thing. Well, maybe you can get by with just a power of attorney and a healthcare document. We use 3 different healthcare documents. So, sometimes it's more simple, you can get by with a level 1, but really you need to, figure out what do you have. I had one guy, he was a professional musician. He had a lot of music equipment, but he was broke. So I said, look, if you just do a handwritten will, that'll be okay. That'll transfer your musical instruments to the different people you want, right? And then, another lady said, I can't afford to pay you, Jim. I just want to make sure my daughter gets the house and not my son. You just do a handwritten will. And she did, and it transferred the house, but it had to go through probate. So there are, times when you don't need the whole suite, but most people need the whole suite.
As a follow-up to Frank Logan's questions, since everybody plans are unique, what's the rough medium cost you charge for a full action plan for over the last few years?
I don't give you rough costs. I give you exact costs. And so we're going to get to that.
Okay. And Bill, did you have something you wanted to say?
I do have one question. We have 3 daughters. They're 2 are in their 50s, 1 is 62. The daughter that's closest to 60, 59 now, is our executor. But our youngest lives in Germany, and she potentially could come in as a executor if something bad happens. And it's unlikely she's going to return in the next 5 years, let's say. Are there any ramifications about that? Could she handle an executor
She
position?
can't. I have a lady now with she's German. So her husband died, and she came to me. We set up everything. She had 3 German friends locally who were going to take care of her, and one was supposedly a professional trustee. As she aged and became a little bit more difficult, all 3 bailed out on her, right? They would not return emails or calls. We didn't know where they were. One of them specifically said, I will not help you. The other one said, I don't want to be called. I want out of this thing. So I had to contact the niece in Germany. And she says, I live in Germany. I said, you stand to inherit a lot of money, but we need some to take care of your aunt now. So she came with her husband. So it's a little bit awkward there because the niece doesn't drive and the husband doesn't speak English, but together they can get all around the area here. And we put the aunt into a memory unit. They come 3 times a year. So, the trust pays for their travel. They stay in the aunt's house. They make sure everything's doing okay. The gardener is under a, contract. They pay regularly. The neighbor has helped them and kind of watches the house to make sure nothing's going wrong. And so every 3 or 4 months, she shows up and she's got her list of questions or concerns and so forth. So she's managing it all from Germany because the aunt is in a memory care unit. So she's in communication with them. And, they have a doctor there and they take care of everything. So, everything seems to be going well so far.
The last comment was an qualification. She did mean Medi-Cal, not Medicare, medical on the question.
Okay, all right, good. We'll get to that.
Okay, let's see if anything new has come in. I think that's it. It is.
All right, so you want to pull down that poll? The poll is still showing on my screen.
I ended it. You have to close it on, everyone needs to close it on their own
Okay.
screen.
Very good. All right. So moving along, let's see if this still works. What the heck? There we go. All right, so now we're going to talk about long-term care and Medi-Cal. So how does our tax system work? So the IRS pulls in most of the money for the country. A couple of big places it goes are Medicare and Medi-Cal. So Medicare is a federal program. That's the same everywhere. Medi-Cal is Medicaid. Medicaid is a federal program administered through the states. So every state has their own twist on it. California, because we're better than any other state, we have our own name for it, okay? So people get confused between Medicare, Medicaid, and Medi-Cal. So Medi-Cal is Medicaid. It's just that we have our own name, and we're different in qualifications from all other states, very different. So who pays the taxes? I had this in there. We had an example a few years ago where Mitt Romney had, a couple $100 million, didn't pay tax. Apple Computer at that time, I believe, had a $4 billion profit, didn't pay a single dollar of US tax. Tim Cook was hauled before Congress and he said, hey, we did it all right. We didn't break the law. Okay. So, there's ways to do it sometimes. So this is a very famous case from 1934. All tax attorneys understand this. Judge Learned Hand. So he said this guy was sued by the IRS, and the judge said, no, he's innocent. He said, anyone may so arrange his affairs that his taxes shall be as low as possible. He is not bound to choose that pattern which best pays the Treasury. So this is my response to my thinking. People say, well, shouldn't I pay for my own way? I said, well, you do whatever you want. The taxpayers want you to pay, but yet you don't have to pay. So if you arrange things properly, you don't pay the taxes. Just like transferring the property to your kids, and you want them to have your Prop 13. There's ways to do that, right? And so you have to just figure out what you want here. Medi-Cal planning is legal and accepted under federal law. Okay, so, people say, why do you do this? How do you do this? Well, it's legal. We do it all the time. Someone said, well, Jim, I think this is illegal. I said, well, one of the big guides that we use is published by a group called CEB, which is the Continuing Education of the Bar, which is part of the bar, the California Bar, and it's actually housed inside UCLA. Okay, so here we have a state entity, which is the bar to protect the public, housed in the state university, telling attorneys, here's the steps you have to take for this kind of stuff. So that is a pretty strong indication that it's legal. The New York Times had this. We have a big problem paying for long-term care in this country, although most people don't wake up to the challenge until it affects their family directly. Right? So what happens is, we have people that just don't pay attention. Who's going to pay for the nursing home? So I say, if we can legally protect your hard-earned assets for your spouse and your family, are you going to sleep better at night? Will they sleep better at night? Okay, so a lot of times the person who's wringing their hands is the spouse that can't care for their ill partner, or they're going to run out of money and they're going to be left, with no money for themselves. The average length of stay in a nursing home is 2.5 years. That's 30 months. Around here, it's about $17,000 a month. That equals about $510,000. Okay. So the question though is, what if you stay longer? I had one client, their mother was there for 10 years. We had another guy that no one knew his name. He was young and he was beaten to death almost, and was in a nursing home for over 20 years. No one knew who he legally was, right? But the state took care of him. So one of my clients came, she started crying and crying when I told her, because her mother had just died. Well, they had spent over $1 million of money on her care at a nursing home in Los Gatos. That nursing home takes Medi-Cal. I've had a lot of clients there. We could have protected all that money. A lot of it was the mother's, but a lot of it also was the income of the daughter and her husband who could have retired earlier if they didn't have to pay that bill themselves. What happens if you and your spouse both go to the nursing home? Well, you're thinking we get a discount for a common room. No, you don't. It's not like a hotel. Okay. There's usually a men's wing and a women's wing, but I have had instances where the husband and wife share a room, but you still pay full bore for each person. So what about the increasing rate of Alzheimer's disease? I got these statistics. This is the changes since 2005. So we have a reduction in cancer, strokes, heart disease, but an increase in Alzheimer's disease. So far, we don't have the magic bullet for that. This, I should have updated, okay, and I haven't, oh, here, but this is the average private pay rate nationally, and they're lower than ours. We thought 2022 nationally would be around 11,000. Well, we're up to 17,000 around here right now. Sorry, I didn't update that one slide. Wall Street Journal, one of the 5 big retirement mistakes is lowballing the estimate of elder care costs. Those things are high, okay? Right around here, you say, well, I can just pay for someone to come in and they can take care of me. Yes, you can. 24-hour care around San Jose area is about $25,000 a month. So if you've got the bucks, you can pay for it. 70% of single people who enter a nursing home are impoverished within 1 year. 50% of all couples are impoverished within 1 year of one spouse entering the nursing home. Mark Twain, if I'd have known I was going to live so long, I'd have taken better care of myself. So that's where we are now. How well you're taking care of yourself. Why don't more people use Medi-Cal to pay for the nursing home? Simply lack of knowledge. Okay, I had one guy who had spent $450,000 before he came to me. He said, well, they said my mom will never qualify because she has a house. Well, that's just a total line of bullshit. Excuse the expression, but just he wasted $400,000 based upon a lie from the nursing home staff. All right, so you have to understand how the system works. Not about care. It's all about money. So, New York Times again. Ask around. Someone you know has faced these facts and probably turned to Medi-Cal. Chances are you, a family member or close friend, will someday too. We are absolutely ill prepared for what is going to happen. We know how to protect your assets, but Thomas Jefferson, again, it takes time to persuade men to do even what is for their own good. So the end result is that most people do use Medi-Cal because they have to, but only after they become impoverished. The wealthy ones, they don't get impoverished, they just spend and spend and spend. So why? The lack of knowledge, lack of planning. People don't know that Medi-Cal planning can be done in advance. You have to be prepared. So people say, well, I'll take care of it when I get there, Jim. Okay, but if you have that stroke or that car accident, you're not coming back to sign anything because you aren't able to. You have to be able to protect yourself and your family. You have to have the right documents in place. You have to have the right support team, right? Will your kids get along? Will they fight? Will they sue each other? Will they steal the documents? Will we have a total nightmare? I write a column every month. Will your family appear in one of those columns as a star in a disaster? Okay? You have to know who's trying to help you versus who's trying to help themselves. So what do these have in common? The IRS auditors and the nursing home administrators. If you've ever been audited by the IRS in a verbal fashion instead of just the letters, they're very friendly. They're there to disarm you and figure out how they can help you pay them a lot more money, right? Nursing home administrators are very similar in this respect. I made a comment one time at a seminar. I said, they're all going to lie to you. So some lady raised her hand. She objected, that I would say something so horrible. I said, you're right. I shouldn't have said that. But everyone I've dealt with in Monterey County, Santa Cruz County, San Benito County, Santa Clara County, San Mateo County, Alameda County, San Francisco County has lied to my client. So you do whatever you want, okay? They say, well, there's social workers. Social worker is actually, that is a profit center, okay? Their job is to get your elder out of the nursing home. So they try it verbally first, right? So I have one there now. And she said, they wanted to know when I'm coming to see my husband. I said, yes, they want to tell you, you got to take him home. But she says, I can't. He's been in assisted living. Then he almost died. Assisted living couldn't take him back. Now he's there in the nursing home. She is on the borderline of being able to take care of herself. She cannot take care of her husband. I said, then the next step, they're going to try and evict him in writing. So I had this lady. So the daughter said, well, they told me I have to take her home. They've given me the eviction. I said, no, there's no eviction. There's nothing legal under federal law until you get it in writing. And so, she told the nursing home, you haven't given me a legal eviction in writing. So she got home at like 8 o'clock at night. Her husband got home at like 9:30. Well, coincidentally, they both checked the mailbox. So when she looked, there was nothing there. When he got home at 9:30, there was the eviction notice, hand delivered from the social worker, quote unquote, social worker at the nursing home. So then I had to write a little threatening letter to the nursing home. I said, that post box is owned and serves the U.S. Postal Service. It's illegal for use it for anything else other than stamped postage. So I said, not only have you violated all the Medi-Cal rules and my client's protection, you're also violating the postal law. Leave my client alone. So we were all in the process of getting the mother's money moved around and her property moved around, so that then within about a week or two later, she was qualified on Medi-Cal. So it's always a rush between these evictions. Now, if you do get a written eviction notice, it says right on it, you have 48 hours to appeal. That's not business hours, and don't worry about holidays and weekends. That's clock hours. So the very nasty nursing homes will put the eviction notice under the elder's food tray at 5 o'clock on Friday. So, before Monday, when you want to call the attorney, 48 hours are already up. So you have to be aware of that. If you lose the appeal, which frequently you do, then you appeal again. You have a chance to appeal a second time. But you have to keep, those timelines. You have to be aware of what's going on. You have to realize that you're fighting against a system that's profit driven. So people say, well, Jim, why would these nice social workers lie to me? Because they get about $1,000 a month more for a private pay than they do for Medi-Cal. Well, why would they lie for $1,000? No. They're not lying for $1,000. There's 100 beds. Okay, that's $100,000 a month that the owner gets extra by getting those people out of there. They don't want long-term care. They want fresh people coming directly from the hospital. Why? Because Medicare will pay initially, and they can bill Medicare a fortune for physical therapy, even if the resident doesn't need it. So who's qualified to advise you? What's in their interest? So when the nursing home is telling you your mother doesn't qualify or that you have to take them home, you have to ask, why are they doing that? Okay. What do they know? Do they know anything? Do they have the law right? I had one lady, she called me and she said, we were ready to do something for her mother. She said, my hairdresser said this will never work. So I said, that's not a problem. Just call your hairdresser and ask her what law school she went to. And once we know what law school went, then we'll listen to her. Realtors tell people you have to sell the house. No, you don't have to sell the house. The financial advisors, I gave you an example of that too. People don't know these laws. So, how do they get paid? They get paid, how do the nursing homes get paid? They get paid a lot from Medicare at the beginning, but Medicare is not long-term. They'll try and evict you after 20 days. Medicare will pay for up to 100 days. But they won't pay 100 days, up to 100 days. So the nursing homes try and get you out. They will tell you a lot of stuff that's not true. They'll tell you that your elder is not improving. The improvement standard, that standard of care was thrown out about 11 years ago in federal court. The law doesn't say they have to be getting better. And Medicare was forced to spend millions of dollars on education. But then they got sued again because the nursing homes kept on using that lie. And so then they had to spend more money on it. So the nursing homes, they know the law, I can guarantee that. But they also pretend that they don't know, and they'll tell you something else, all right? So you have to watch it. So they get paid a fortune on Medicare, they get paid a lot less with private pay, and then about $1,000 a month less from Medi-Cal. So you have to follow the money, okay? We do two types of planning, crisis planning and proactive planning. Proactive when we get ahead of and get things ready ahead of time. Okay, I've had people, one lady had 8 properties. She said, no, Jim, I'm going downhill. And one daughter disabled, the son's disabled with some addiction issues. The other daughter's okay. She says, my husband died. I don't want to be a burden and I don't want to lose all my properties. So she got ready well in advance. She's still alive now. We did that like 9 years ago. Medi-Cal planning is a specialty. Okay, if you don't deal with someone that does it all the time, they don't know what the rules are. People say they want to die at home. Most Americans want to die at home. I'm one of those. I want to die. Actually, I don't want to die at all, but if I have to die, I want to die. But the statistics say that back in 2010, only 27% of the Americans lucked out and died at home. My great aunt, she used to say, Jim, did I tell you about my death wish? My death wish? Yes, you told me. So when she was 98, she kept on saying, get ready, I'm going to go to bed. And, on my birthday, I won't wake up. I'll be dead. Well, she woke up and she was very upset, okay, because she wanted to die, but she didn't. So you have to figure out what's going to happen. So you have to get qualified. We have to look at assets, gifting, look back period, penalty period, which is a period of ineligibility. It's not a penalty of cash. And we have to avoid estate recovery. That's when the government gets their money after you die. So what do the clients want? They want the government to pay now. They don't want to have to pay it back after death. You have to be medically eligible and financially eligible. So there are people that are broke. Well, they can't go into a nursing home because they're still fine. They're walking around. Okay, you have to figure out. Another part of Medi-Cal, I think we touch on it later, is called IHSS. That's in-home supportive services. Okay, that same thing. You have to be financially eligible and medically eligible. So the financial part, we look at income and we look at assets. California is what we call an asset state. So we don't care what your income is, but we're going to take it from you, right? So people say, oh, I make too much money. No, you don't take money. It's just going to go to the nursing home. So this is the law that's supposedly coming, but it hasn't come yet. So this is the open door opportunities for planning now. We thought the state was going to close some, but now we got a surprise. Things are even easier right now. So there's something called the MIMNA, the Minimum Monthly Maintenance Needs Allowance. That's the Spousal Impoverishment Act. So if you're married and the spouse at home earns less than $3,716 a month, they can keep the income of the ill spouse up to this amount. All right. So if you each make $3,000, then the ill spouse in the nursing home, $716 a month will go to the well spouse at home, and the rest will go to the nursing home, except $35 a month. The person at the nursing home always gets to keep $35 a month for their personal needs allowance. With the rate of inflation, I think that's 2 lattes a month. All right, so this is the financial requirement. So it used to be $2,000, if you look on the left side, for the people at home in the nursing home, and the one at home could have $128,000. Now that changed. So currently, the one in the nursing home can have $130,000, but if it's a couple, they can have a combined $195,000. But January 1st, it goes to unlimited. All right. So if you have 5 houses with $5 million, you can still get Medi-Cal coverage after January 1st. So in the last couple of months, I've been telling people, well, mom's doing okay. You don't really need to pay me, because if she hangs on until January, we'll be fine. So we have one now that we're just going to plan and move some money a little bit in case we have to, but the new law is January 1st. So I said, as long as everything's ready, January 1st, we apply and everything's okay. So we talked about the income a little bit, what's counted, what's exempt, what your documents allow you to do, what about mental capacity, okay? So the proactive planning, we plan ahead, we use a specialized irrevocable trust. So we're still going to use these things down the road to protect income. Because if you have a rental property that throws off $5,000 a month, that $5,000 a month will go to the nursing home. So if we put the rental house into the asset protection trust, then the income stays in there as well, right? So there's certain circumstances we're still going to be using these trusts. What's the benefit? We have the eligibility. We help stop elder financial abuse and undue influence because you can no longer sign. You cannot be the trustee of your own trust when it's one of these irrevocable trusts. We still have the residence exemption. We still have the step up in basis. We still protect Prop 13. So you get those good things. We have had problems with a couple of brokerage companies where they declare, they send a huge tax bill or the paperwork for a tax bill to the heirs afterwards. And we had to go back and fight with them and said, no. You misinterpreted the trust. Here's what the law is. And every time they've agreed and they reissue the paper so that the people don't pay the tax. In one case, the client called me and she was upset because her sisters blamed her and me. They owed over $300,000. I said, well, it's a good thing you blamed me for this because it's untrue. So the stock had gone up since the dad died, but they owed less than $20,000. They didn't owe more than $300,000. The brokerage company simply made a mistake. How much does everything cost? That was one of the questions. So Abraham Lincoln said a lawyer's time and advice are stock in trade. That means we're not selling products here, we're selling our time. But people don't like to have surprise bills. And so I do almost everything I do is fixed price billing. So the whole trust package that we talked about for the revocable living trust, for a single person, $3,750, for a married couple, $4,250. That includes the transfer of one piece of real estate, one transfer. So if you come in and you have a rental too, or you come in and you're single, but the house is still owned by you and your deceased spouse, then we have to do double hops. So that's an extra $450 to get it in your name and then put it to the trust. On the Medi-Cal trust, we usually charge $20,000, but sometimes it's higher depending upon what is in there and how many transfers we have to make. So I had a lady a few years ago, we could only gift a certain amount per day, and she had 3 properties. So the residence was exempt. The 2 rentals, we had to do multiple deeds, so it cost much more. So for the revocable living trust, we're going to meet, we do the interview, maybe we meet and you don't know what to think, and so you come back, then we do the interview, then you come back and sign, maybe you have some questions. But for the Medi-Cal trust, this is an example of one family that we did where we met with the wife and kids, and again with the whole family, and then with the financial planner and the phone call. So sometimes that goes on. That's why we charge a lot more, because we know there's a lot more to it. Then usually I have to talk to the CPA, and then after the death, I have to talk to the CPA again, and we have to straighten things out. So we recommend 3 years. You do a checkup, you look at it, make sure everything's okay, read it. If you don't know how to read it, you come in and I'll look at it with you, okay? Even if you're not my client, I just do that. I say, are you okay or you're not okay? Are we going to have a problem when you die or not? So are you prepared? Have you taken the steps to protect yourself, your spouse, your heirs? George Patton said, prepare for the unknown by studying how others in the past have coped with the unforeseeable and the unpredictable. Every day, every week, I see disasters come across my conference table. This is what I deal with. My experience is there to help you avoid the same pitfalls that other people had. So you have to prepare a proper plan. It's not easy. It takes a qualified attorney who's practiced at both estate planning and elder law. So I know some guys that do a lot of estate planning, but I look at their power of attorney. It's like, well, if your client has a stroke, they have an agent, but the agent is not allowed to do what has to be done to protect the assets. I took over for an attorney that died. People come in from him, and I said, well, I know what it says, okay? You know, you named your spouse, and now that your spouse is deceased, you have no agent on the power of attorney. That attorney always just named the spouse and no one else. Okay. Another one came in, and sometimes there's springing powers of attorney have been outlawed in Florida. I know that because I'm licensed in Florida. I worked there when I started. So people come in, as you know, I said, well, you know, you have to have the power of attorney. I have it right here, Jim. I said, well, it's not valid, so you get 2 doctor's letters to say that your spouse is incapacitated. So, you know, they said, not a problem. I'll get it. I'll be back in 3 days. Okay. But I had another guy that he wanted the neurologist to write a letter that his wife was incapacitated. Well, she wasn't too far gone yet. So after that experience, she wouldn't speak to him for 2 weeks. She was so mad at him. He said, Jim, how am I going to sell the house? What am I going to do? I said, well, why don't you bring her in here and you and her both agreed to resign, and then the 2 kids are in charge. So since he agreed to resign, she agreed to resign, the power passed to the kids who are the successor trustees, and then the kids sold the house and moved the people to Oregon and bought them a new house. Okay? So you have to figure out how do we get around the issues. So these are a couple of stories. I'm an avid reader of the New York Times. New York Times, they have this section, it was on Mondays, now it's on Sundays, called Metropolitan Diary, where people write in about some experience 20 years ago or 50 years ago, or they came back to New York, same restaurant still there. So last week they had one about this guy that came from Holland every couple of weeks to New York, and he needed toothpaste. He went to the pharmacy and he couldn't find it. So he asked one of the employees, what's downstairs? The guy says, everything that's not upstairs. Okay, so it's very clear. Everything is downstairs, it's not upstairs. So sometimes it's very easy. So I had a couple come to me. They tried to get this, the sister's husband died and she moved in with them 20 years ago. They tried to get her on Medi-Cal a couple of different times and they couldn't get her on Medi-Cal. At that time, the limit was $2,000. Well, the sister kept on getting declined because she had $6,000. But they told me she owes $5,000 to the dentist and they make monthly payments. I said, just write a check to the dentist tonight for $5,000. Tomorrow she qualifies. And they looked at each other and looked at me and said, why didn't Medi-Cal tell us this? They're not there to help you get Medi-Cal. They're there to tell you you don't qualify. I've had people that do it wrong, they lose their house. Skip the next one and go to the last one here. This woman called me crying and crying. Well, they'd been to me before, and at that time I charged $10,000, and she told her mother, this attorney's a ripoff, don't use him. Dad was in the nursing home. Well, now she's crying because she found out that mom paid $550,000 for dad's care before he died. Now mom was out of money. Okay, so if they would have paid me the $10,000 at that time, we could have saved the $550,000, and now mom would have money to pay for her own care.
We have a couple of questions, Jim.
Okay.
With regard to agency, how does one include contingencies within an estate plan?
Well, as far as agency, that's under the power of attorney or the healthcare. You name a successor. So I name my spouse. But if something happens to her, I name my brother. If something happens to him, I name my son. Okay, so we have in success, you know, successive order. The same thing with the trust for the successor trustees. Sometimes you say, I name my spouse. But if something happens to my spouse, then I've got my son and my stepdaughter together by unanimous decision because neither side of the family trusts the other one completely. So we lock them together. And that's how we handle that.
Okay. Now here's one for you. It's a little personal. Who will review the trust when Mr. Ward retires?
Well, I take vitamins and I exercise. I'll never retire. Okay. So you'll have to, you know, pry my business out of my cold, dead hands. So we are very digital. I've taken over from 3 attorneys who died, and it was a disaster. They had no mailing list. We mailed every client usually twice a year just to make sure we keep up on everything. But we have all the files. So it's a good business. So someone will take it over. So if I'm ill, I know a couple of guys to approach to see if they'll take it over. So the files will pass to the new person. If I get hit by a bus, my wife and my brother know who to reach out to and how to transfer. So there could be a month or two where no one's running the show, but it'll be taken over by someone, and hopefully they'll pay a good sum of money to my heirs.
Yeah, this was an excellent question because as an executor 40 years ago, I lost a family member, and the estate came to me to handle, and the attorney up and died on me.
Yeah.
And so I had to break in a new attorney.
I had one. So the bar will appoint an attorney to take over any ongoing cases. All right. But you don't want to get stuck with someone like that. And so our cases, we finished within a few weeks or a month or so. So they're done. But you come back, you have questions, we're still there. But I had a family come to me, and they had the same thing like you did, Bill, where someone died and halfway through someone else died. It was just a nightmare. They were almost at the finish line, and then the judge died. So then there's a new judge, so they had to educate the new judges to all the history and stuff. So we don't do any litigation, but some litigation cases will go on for 10, 15 years, and then it's a problem. But our deals were usually done pretty quickly.
Okay, here's the last question I see at this moment. If you want a bank or as a successor executor, do you set that up with the bank in advance?
Yes and no. So I usually don't. You can show them the documents, okay? And we've had banks that went out of business, but then their assets are taken over. So then, whoever took over that bank's assets are now the new trustee. But generally, we haven't had any problem with our trust when it goes that way. One thing that we have had a problem, I'll just specify that when you want to give money with strings attached to a charity, okay? So you have to be careful there, because I had one guy, he said, I want to donate only to women in need to go to this junior college, and they have to be from my town. The junior college says, we won't take that money because we'll get sued because the instructions are too particular, and we'll have to spend a lot of money trying to figure out if we meet those instructions. So he said, okay, forget it. Just give it to the college and give it to any women. Okay. And so, then they could take it because they could figure out, at least at that time, it was easier to figure out who was male and female.
There's also a couple earlier questions.
Right.
Thank you for the answer to my question earlier about protecting assets from children's spouses. Your answer was via setting up sibling inheritance. Here's a slightly different question. Was the best way to structure trust distribution to our children to protect the inherited assets from their spouses?
That's very difficult to do. I mean, we do it, and we have a specialized trust for that, but it's very burdensome and cumbersome. And so you have to say, what's the interest and what's the danger, and what's it going to do? So now, let's say there's a lot of different scenarios, but one thing that we'll do, let's say you have a drug addict or alcoholic child, or they're married to a child, your child is married to someone who will take all the money. Well, then sometimes we pour it into an annuity. And so then it just disperses over 10 years or 20 years so that the spouse can't get their hands on it all at once, or the alcoholic or drug addict can't get it all at once. So we buy those annuities and we stretch it out.
Okay, the next question was, please confirm to be eligible for Medi-Cal, your financial assets have to be close to zero and you can own a home. Please confirm Medi-Cal will take a lien on your home once you pass.
Okay, so I can't confirm that. That's wrong. So your house is a protected asset. All right, so even if it's a $10 million house with no loan, it's protected. So it does not count against you for eligibility. However, upon death, they'll attach a lien to it. But if you have the house in the trust, just a regular revocable living trust, it is protected and no lien can be put against that house. All right. So we used to have to do an irrevocable trust to protect the home. Then the law changed and we could do a revocable trust to protect the home. Right. So the home is not counted against you, and it cannot be attached by Medi-Cal after your death.
Okay, next question. The husband has been diagnosed with Alzheimer's and will likely be in a memory care unit or nursing care home within a few years. If the couple applies for Medi-Cal to help pay for the husband to move into memory care or nursing care, the share of cost model would not provide enough money for the wife to continue living in their home with a mortgage. What can they do to prepare for this situation?
So the Medi-Cal will not pay for memory care, will not pay for assisted living. Okay, and people say, oh no, Jim, there's a program. Well, I go to these meetings that have like 300 people in the room. They're all elder law attorneys, and no one has ever had any client who ever qualified for that. So it's like 2 or 3 people in the state get it each year, maybe. So don't bet on that one. I've never heard of anyone getting that. So they won't pay for the memory care, but they will pay for what's called IHSS, which is in-home supportive services, and they will pay for the skilled nursing facility. So they pay kind of at both ends of the spectrum, but not in between. Now, what can you do about share of costs? So depending on where the income comes from, we can move the income via the irrevocable trust, so it's not yours. But we cannot do that with pension income, and we cannot do that with Social Security income. But if it's rental income, we move the house. So the rental income stays in the irrevocable trust. If it's stocks and bonds income, we move that to the trust. So all that income is protected. So it depends on what you have there. Now, regarding the mortgage, sometimes we have people that get a reverse mortgage. Now, reverse mortgage, people shudder at the thought. Well, sometimes it's the best thing in the world. It'll keep the couple at home. It'll keep paying the bills. But I had a guy, and he called me, and he said, I'm going into foreclosure. We haven't made the payments for a number of months, and we don't know what to do. So I said, well, if you lose the house, you're going to pay a horrendous amount in capital gains tax. And where are you going to go live? He says, I don't know. I said, you need a reverse mortgage to bring you current and stay in the house. He says, my son doesn't want us to get a reverse mortgage because he doesn't want to inherit the house with a loan on it. Okay, well, can you go live with your son then, since he's the one that wants you to suffer? No, he doesn't want us. Well, what are you going to do? So the issue is people want to help their kids in most cases. But my theory is you got to help yourself. So we're doing a reverse mortgage for a lady now because her husband died and she has no money. She just needs to fix up the house. She just needs a little bit of money and to keep on going because she's not near death yet. She could live another 10 years. So she didn't want a reverse mortgage till her friend said, well, that's what I have and that's how I live and that's how I can have vacations. And so people say, well, then they're going to take the house. They don't take the house. They're going to get their loan paid back. So if you die and your house is worth $1 million and you owe $200,000, they're just going to get the $200,000. I have a lady now, she owes like $500,000 on the reverse mortgage when her husband died. I said, yeah, but you have $400,000 in the bank. So you can pay down the reverse mortgage so you're not accruing so much interest there and then take it back out if you need it. Because you still have other money and you have your income and, they pulled the reverse mortgage not for his care, but to buy a vacation home in Southern California, which she will sell within a year or two. She just emotionally can't sell it yet. So she'll be fine. So you have to just realize, what makes sense? How are we going to do things? Okay.
That's all the questions I see. Does anyone else have any other questions? Does anyone else have any questions?
All right, so I got a couple of slides left here. So he say here, with my apologies to Neil Armstrong, one small step for you, one giant leap for your family. Get it done. So I have the 2 other companies. I have J. Ward Financial and Pathfinder Financial Solutions to take care of people. And I did this at the insistence of my clients to help them. So I'm 100% owner of both those companies. I have to have 2 separate ones for a tax purpose. So I have the law degree, the LLM degree, the CFP, and the RICP, and then I'm also a EdSlot IRA Elite Advisor. Okay, so these are the things I bring to the table. A lot of what we do is just try and stop you from making massive mistakes that are costly. That's what we have to think about when we go through this process. Right? And I think that's the last slide. So thank you very much. So if there's more questions, we can still go through questions. I have time.
I don't, how can I ensure that the terms of my trust will be executed by the executor as directed?
The trustee is essentially like the bus driver. Okay, so they don't own the bus, they just drive the bus. So they have to follow your instructions. So in one case recently, because we know my client and her sister are both clients. The sister died, she's supposed to get everything. But the brother, who they didn't trust, came out of nowhere and is suing. So we altered my clients to say that the trustee cannot settle a lawsuit. They have to use all the money in there to fight the lawsuit, because we know this guy will sue, right? And she doesn't want him to get a penny. So that's an extreme case, but usually there is some flexibility, but they have to follow. You know, we have a case now where the son was in charge. Well, when dad died, his wife sued and got $850,000. Then the son moved into the big house that he was supposed to sell and give money to his two sisters. Well, he rented out his house, and he has no kids and he has no wife. And so one of the daughters comes to me and said, what are we going to do? Well, he's been there for like 12 years and he hasn't sold it. And he just keeps on telling his sisters, I'm fixing it up. Well, they're both single parents and could use the money because the house is worth a couple $1,000,000. And he's just living in the big house and not paying any rent. So I said, well, you have to sue your brother. The court will remove him and they will charge him with 10 or 12 years of non-payment of rent. That'll come out of his share. Oh, we don't want to upset him. Fine, keep living on food stamps. I don't care. But if you want your share, you have to ask the court to intervene, because the father's instructions are very clear. So your brother's the trustee and he's cheating all the beneficiaries. That's not allowed by law.
How do you convince someone that they shouldn't try to do their own estate plan?
Well, we can tell them about all the disasters that we see. So it's like, if you don't care about yourself, you don't care about your beneficiaries, you know, I had a professor when I went through the program. He says, Jim, he says, you got to look people in the eye. You have to say, I will never care about your family more than you do. If you don't care, neither do I. I got my own family to worry about. Right. So, you know, I can't convince you if you don't want to be convinced. If you say, well, I don't really care about my spouse or kids, not a problem. Burn down the house, do whatever you want, you know. Well, I don't care about my health. Hey, go to drugs. I've heard it's really great, you know, whatever. So it's like, you know, I can't. Now, if it was my child, I would do everything I could to convince them. But, you know, if it's just a client and they don't care, what can I do?
A number of questions have come in. For a young boomer, 61 years old and in good health, what's the optimum time to go through Medi-Cal asset protection process, given the cost and complexity?
The optimum time, what you need to do is get a full trust done with all the associated documents so that the person you trust can do the other one later if ever needed. Right? So a lot of times you'll never need it. But if you need it and you don't have the right power of attorney and the right trust, then we can't do it. That's the problem. Right? So if you have the good power of attorney and the good trust, then, and you have people you trust in charge, they can come in later. So sometimes I have couples I do it for, and they even want it, you know, pay me. I said, why? Don't pay me yet. You know, you're not ready for the nursing home yet. Well, what if I have a stroke? Well, then your wife can come in or your son can come in and we can do it then. All right, so you don't need to pay ahead of time in most cases. You need to make sure you're ready. I tell people, it's like, have you ever seen the guy with a horrific car accident trying to put on the seatbelt after the impact? It doesn't work. You got to put it on ahead of time. Tell people for the rest of your life, you never need to wear a seatbelt as long as you can always plug it in within 1/1000th of a second prior to impact. The reason we wear it all the time is because we don't know when that impact is coming, and none of us have the reflexes to plug it in that fast. Right? So you have to have the trust package in place now so that someone else can take care of you if you have a stroke or a car accident or fall off the ladder or whatever.
Okay, the next question is, if one has nobody, how can one find a fiduciary to handle finances and healthcare decisions?
Well, you can find fiduciaries, okay, you can find them on Google, you can call attorneys and they'll say, here's some fiduciaries in our area, you know, and you say, well, who have you worked with, who's good? And the fiduciaries, they die and they retire too. So you got to figure out, is it just a one person operation or there's a couple of them there, right? Or you say, well, I can't find any. I'm going to name my older sister who's in poor health, but if I outlive her, then we got the bank. Okay, so the trust company will name people to take care of all those things for you.
The next one is something my neighbor tried to convince me to do, was make changes to her trust. And the question is, can I make minor changes to an existing long LT with a different type of paper, or should the changes only be made by an attorney?
Depends. I have people come in all the time with changes, but they're not legal. They aren't going to work. So, if no one disputes, it doesn't matter. But the question is, if you want that change followed, you have to make sure it's legal. You have to follow the same formalities. So if your trust was notarized, the change has to be notarized. Okay. And if you want to scribble it out longhand while you're in the hospital, you have to ask, can we read it? And now is someone else going to say that you were forced to do it? Undue influence.
Do most nursing homes work with Medi-Cal? I've heard nursing homes that take Medi-Cal are very substandard.
So I meant to cover that. I didn't. 99% of the nursing homes in our area take Medi-Cal. Otherwise, they can't keep the beds full. But they'll never mention it. You look at their websites, they don't mention it. I had a financial planner and her son come to me. Her mother was in the nursing home. She said, Jim, they gave us 6 different payment options and never mentioned Medi-Cal. And then my son brought it up and they go, oh yeah, you could do that too, but we no one here does that. Well, we got the mother on Medi-Cal immediately. So they're never going to tell you about it because they're trained not to mention it because they get less money. But, I mean, we have them, in Los Gatos. I mean, in Saratoga, we have people in really nice nursing homes that Medi-Cal pays.
My brother-in-law is in a care home, and it's Medicaid covered, and it's a good home. The last question I see is, who must...
Before your question, let me tell you 2 stories. Okay. So a buddy of mine who was a tax professional, his mother went to a nursing home in Capitola. So he said, Jim, that place has the best looking employees I've ever seen. He says, if you get sick, that's where you want to go. And if you want, and some of these nursing homes are pretty noisy. If you want the quietest one, it's owned by a group of nuns out in Los Baños. And man, it's quiet, wide hallways, land is cheap out there. And it's just beautiful and they get excellent care. The problem is how you're going to see your elder if you have to keep driving back and forth. But that was a beautiful facility.
Okay, the last question I see is, who must sign a trust? The attorney, the executor of the trust?
No, the grantor has to sign it. The grantor is sometimes called the trustor. That's the one who's putting the money in. So they have to sign it. So sometimes they're signed twice because they're also the trustee. So if someone comes to me and they want their son as the trustee, I said, okay, well, you have to sign as the grantor and your son signs as the trustee. And we have 2 different lines for that. Usually the same, if we go back to the 61-year-old boomer there, if that person is competent and alert and all that, they are the grantor and the trustee. So they're in charge of all their own stuff until they can't be. And then we have the successor. So in the event of resignation or incapacitation or death, then the successor takes over. So a lot of my families, I tell the elders, like, hey, do you still want to be in charge, or do you want to resign and have your son run it? So this one guy, he just turned 90, and then he was, it should be 99. He was healthy. Then he went downhill a few months later, but he's still saying, no, Jim, I can still do it. I want to be in charge. Okay, so he's still the trustee. Right? But down the road, we may have to make his successor trustee co-trustee with him, or have him resign, and the successor trustee is the only trustee.
Okay, there's one more question that came in. Does your living trust package cover a disabled child?
Yes and no. So it does. So everything is in there to cover that if they're disabled. So for some kids, we force the money into that. We don't want there to be any question as to whether or not their money goes into a supplemental needs trust. And that's to protect it. And so, in other ones, it's like, well, they're healthy now, but if they are sick or if they have an accident or they have a stroke, then their money goes in there. So it just depends on the situation. So sometimes we force it in there just so that they can't spend it, so that they're protected and they have their long-term protection.
And you would,
Some attorneys will say, oh, you have a disabled son, we have to do a supplemental needs trust. And they'll charge you an extra $4,000 or $5,000 for that. I say, you don't need that trust until you die and your son is still alive and disabled. The only time you need to pay for that trust in advance is if your brother or sister or mother wants to leave money to your disabled child. If all the money is coming from you and it's coming after your death, then my trust, you don't have to spend that $4,000 or $5,000. The supplemental needs trust for your child is built into my trust and is triggered upon your death. And it's like 10 or 11 pages that are already in my trust just for that purpose. So you don't have to write a new trust.
is it best to have,
So then the money will go into, I'm James Ward, so the money would go into the supplemental needs trust of Robert Ward, created under the James Ward Living Trust.
if it's part of your living trust, is it best to have a separate trust document for the special needs trust, that you don't have to give the entire trust to the administrator? Or does that matter?
Well, it depends on the strength of your hand. You're handing a document that has an extra 10 pages, but you've saved $5,000. Okay. So again, we need that trust ahead of time if someone else is going to contribute money. But if it's all coming from you and it's not coming until you die, and if you say, well, Jim, I want to set it up now, well, fine, you can do that. It just costs extra.
So a supplemental trust can accept assets from anyone, not just the grantor of the trust.
Correct. So sometimes we have people that say, no, my sister has no kids. So she dies first. She's leaving money to my disabled daughter. Well, okay, then if that's not in her trust, then, which it should be, then we just create a new trust. So, I've had people come in and they're furious because they're losing their disability because they inherited $50,000. So they're furious. Well, mom didn't do her trust right.
Okay, one more question came in. What is the difference between trustee and fiduciary? Do you provide a copy to the trustee?
Well, the trustee is the only one in charge. Okay. So the trustee is a fiduciary by law, but the trustee also may be a private fiduciary. Or maybe the trustee, their job is to sell the house, give half the money to Bobby and put the other money into a trust for Susie, who can't control her spending, and then turn it over to a private fiduciary. But a trustee is governed by the fiduciary laws of the state. They have a fiduciary duty to every beneficiary. So, excuse me. So if you name your son as the successor trustee and you stroke out, that your son has a fiduciary duty to you because you're the primary beneficiary until death.
Okay. I don't see any other questions. It's been a very good presentation. Thank you.
Thank you. I hope it wasn't too repetitive, and I hope I didn't flog too many dead horses, but
Well,
It's,
you did a great job. Thank you.
We have another question.
okay.
Did
I am in California. All trustees in Massachusetts. Will that work?
As long as you trust them, and as long as they'll do their duty, it works.
Do they have to come to the state to do business?
No, but we would simply, set them up with someone, an attorney, take care of it. And they'd have to sign a fee agreement, provide the documents, and then what happens is usually the attorneys that do this have a paralegal. So I say, you can talk to the attorney daily if you want. They're going to bill you an arm and a leg. If you let the paralegal do her job, she'll call you when it's time to make a decision.
the
Okay.
other The other question that wasn't asked is if you have property in multiple states, will you need a trust for each state?
No, but if you have properties in multiple states and you don't have a trust, you'll go through probate in multiple states. Okay, and that'll be a killer in cost. So we have a lot of clients that have properties in other states. We just do a California trust. When we have to transfer property in Alabama, Arizona, and Nevada, we hire an attorney in those states to do it. Okay, and then they record the deeds there. So I had a client came in and they said, "Oh, Jim, we have a house that we bought that our daughter lives in Reno." Ah, crap. I said, that's going to cost like $700. By the time we find an attorney out there to do it, and we charge an extra $200 for the administration, running it all and all that. And they said, well, we're buying another one too. I'm like, oh, wow. Well, you haven't bought it yet, but now we're going to have the trust done in 2 weeks. So I said, go back to the, and they said, well, I said, ask the title company, they'll put it in the trust. And he said, well, it's the same developer, same title officer, same title company as the one they bought a year earlier. I said, oh, wow, go back and see if they'll do the first one. So the woman said, sure, we'll transfer them both. So they saved $1,400 by just going back. So when you buy something, the title company has to know who owns it. Who do you want to own it? Is it Mark and John? Or is it Mark and Susie as community property? Or is it tenants and commons or joint tenants? No, take it in the name of the trust so you save money.
Okay, a couple other questions have come in. I hear you speaking about taxes. Are taxes handled as part of the living trust package, or do we need a tax professional?
Well, you need to do a tax return after death. You have to do a partial year tax return of the person who died, and you have to do a trust, a state tax return as well. But I've had kind of tax classes, even as an attorney prior to the CFP. So we talk about taxes a lot, but I don't do the return for you. And so, I steer you away from, huge problems of capital gains tax. Like people say, well, my daughter wants me to add her to the house now. Well, okay, well, now we're going to have a problem with, with lots of issues. Are you still sure you want to do this? Okay. And how do we do these things? So you have to just think about, we talk about it all the time. So a living trust doesn't change anything on taxes because you can still change everything. Now, irrevocable trust, we do what's called a grantor trust. So everything still flows through the grantor's personal tax return. So we are not taxed at the trust level. So when I do them, the knee-jerk reaction with CPA is, oh, your attorney screwed up. Now we got all these taxes. No, you don't. Read the damn document. And you'll see it's a grantor trust. There's special rules under the IRS for that.
One more question. Can you talk about tax aspects of MAPT, I mean stepped up basis aspect?
Well, it depends on who did it. So mine, the Medical Asset Protection Trust, we got to step up on basis and everything. We've never failed to do that. Okay, that's just the way the trust is done. But I've seen some where it's not done. So I had two clients, coincidentally, kind of at the same time, who the attorney had done an irrevocable trust to get their spouse, their husband, on Medi-Cal. It worked, and then the husband died, and now they're stuck with this trust. One lady says she was going to owe $800,000 in capital gains tax, that her son would owe when he sold it after, And I said, well, so in one case, we could get around it ourselves. And the other case, we had to go to court and have the court undo the trust. And then the lady saved, or she or her son, whatever, saved $800,000 in capital gains tax. So mine worked. We've never had one fail, but I've seen other ones that do fail.
Okay, so that answers the rest of the question. Isn't the growth of assets since MAPT was created taxable to the beneficiaries?
You still get a step up in basis at death.
Okay.
So if you put a rental house into the irrevocable trust and then sell it before the grantor dies, you still owe the same taxes you would have owed before.
But you do get a stepped up basis when the grantor dies.
When they die, correct. So I had a lady and her husband, they had a strip mall, and they'd which means a line of buildings that didn't have a strip joint. It was a strip mall. And they had it sold a couple times and it fell through. And now they had a buyer. It looked like it's going to close a couple $1 million, and the husband dies. Huh? So the wife comes to me and she says, "Well, Jim, I still need to go ahead with this 1031 tax deferred, exchange that my husband set up." I said, "No. I said, your husband died. You have a step up in basis. You have no capital gains tax if you sell. Okay, you don't need to transfer into more real estate because you owe no tax." She goes, "You're kidding." "No, really." So no one told her that. And so you just sell it, you take the money, you do whatever you want. But there's no deferred tax because of the step up in basis. There's something else triggered me about separate property before. So sometimes we have a couple, but one person has separate property, okay, that they inherited. And so sometimes we'll do a joint trust for the couple and a separate property trust for one spouse.
How would we schedule a first appointment and what would we bring to prepare?
Well, if you're having illegal documents, you bring those. So there's 2 phone numbers there. You can call either phone number. The phones in San Jose are directed to Gilroy because we're in San Jose just usually 1 or 2 days a week. And we'll schedule it for you. So if you want me to review what you've got, or sometimes people come in and say, "You don't need to read it, Jim. It has to be replaced," or whatever. Okay, but bring it with you so we see what it has. And even if we know we're going to replace it, I want to make a copy to make sure you have the legal authority to replace it. We don't charge for those visits. Okay, so if you come in, you want an opinion, we don't charge. And then I'll tell you, here's what it's going to cost. Here's what I think you should do. And you can come back or not come back. And some people say, "Well, we're just going to do it right now." Where do you want? So if we're doing it right now, we also need your driver's license. What we eventually need is to know the correct spelling of the legal name of every person. So I don't want nicknames. We're doing legal documents here. Okay, so we have to have the right name so that we don't have to figure it out in court later, or we don't have your son go to sell your car at the DMV and his ID doesn't match what the power of attorney says. And so then we just walk through. I tell people I need to know your address. If you don't know it, it's probably on your driver's license. If you don't have a driver's license, you bring a passport or a senior ID. And sometimes it's changed with the real ID, but I had women before that said it's hyphenated, and the DMV wouldn't hyphenate the name, but the State Department did for the passport. But now on the real ID, they're using the hyphens. But I've also had people that come in and it's the wrong name. It's misspelled on the ID. I said, "Well, you need to get the real ID and get it cleaned up." One guy came in and he was like Walter Johnson III. And he says, "But Jim, that's not real." He says, "My buddy and I dared each other when we turned 16 years ago, and they both went down and got their ID that called them the third, and they weren't even the junior." But the DMV did it during those days, back in the 60s and 70s. I said, "Well, you better go get a real ID or a passport so that we know your real name and change the name on it," because he had that fake name even on his real estate and his property ownership. So you have to have the right name. You also have to know if you're married. Okay, so I had one lady and she said, "I'm married." Okay. She started talking. I said, "I don't think you're married." She goes, "What do you mean? I'm married." I said, I don't think you are." She goes, "Yeah, Jim, common law marriage." I said, "Great. But we don't have that in California. They've been married 27 years. I said, "You had that back where you came from in the Midwest, but you didn't live there long enough to meet the requirements of common law marriage in that state. If you would have met it and moved to California afterwards," I happen to know Rhode Island is 10 years. So if you live together 10 years and moved to California, we respect it. But if you moved after 9 years, you never met the requirement of Rhode Island, so you're not married." So I said, "You've been committing insurance fraud, benefits fraud, IRS fraud for all these years." I said, "You better get this cleaned up." I hope I don't talk too fast for anyone. I just try to get everything answered as much as possible.
Are we done with the questions now?
As many as I see, we are done.
Okay, I'm going to say, wow. Jim deserves a huge debt of thanks. Terrific, Jim, and your competence really shines through. Really appreciate your presentation.
Thank you very much. I've been doing this a long time. I love it. Love helping people. So the phone numbers are there. You can look me up online. You know, I have a website, read the website, but if you want to talk, just call, make an appointment. We don't charge for that.
Thanks again for Deborah and for Bill and for James for a terrific presentation and great questions, by the way, from all of those who attended and asked them.